Our next very interesting copyright story involves this poor woman, Lily Chin. She made I guess this is an Instagram post. She runs doggydrawings.net, and this is on the doggydrawings.net blog and news, but this is my copy of it, just in case she took it down or changed it or something. She complains of art theft by Old Navy, and she shows these examples. 2014 copyright by Lily Chin on the right shows a Bichon Frise, and Old Navy toddler sleep set is on the left, and her French Bulldog is on the right, and Old Navy's on the left. And here's more examples. Her English Sheepdog, French Bulldog, Cocker Spaniel, Papillon, Bichon, and Foxhound all appearing in this set of pajamas made by Old Navy. And she complains that her art gets stolen all the time, that she has been through many copyright issues that have been resolved amicably. Apparently, Old Navy Gap is being totally unapologetic, have said that it would be a bad business decision for her to expect to be reasonably compensated for her art. Instead of compensating her, they hired a law firm to fight her, and so she has filed a lawsuit in federal court. Now, she's filed this in March 9th, 2018, and she says that she's a well-known illustrator. She makes dogs of the world. And then she discovered that Old Navy was selling a pajama set made with her Dogs of the World stuff. Open and shut case, right? I mean, super simple. Those dogs are obviously copies of Lily Chin's dogs, unless someone's going to tell us otherwise. Well, Old Navy has come along, and Old Navy has told us what's really going on here. They have answered Lily Chin's complaint, and you can tell from my dramatic tone of voice that it is going to be a totally fact-filled and revealing source of information about the complaint. No, exactly the opposite. It is the bare bones, driest, non-answer answer that I've seen. They don't even deny the allegations in like the traditional we deny the allegations language. They just say we lack information, knowledge or information sufficient to form a belief, which is a kind of denial. I mean, a judge wouldn't look into that and be like, yeah, you didn't deny that. But you're required to deny in your answer under, I think, Rule 8. And so all they're doing is going through here and denying. And the only real kind of fact I found in here is that they deny that Old Navy sold any goods featuring nearly identical copies of plaintiff's works. They admit that they previously sold the pajama set and that they lack information and belief. So this is the barest bones answer that I think you could probably... This is basically the minimum answer you can file. It admits that they're a corporation, but it lacks and denies knowledge of everything else in general. It presents affirmative defenses that are all standard, but it fleshes out none of them. So what this says to me is that this actually kind of confirms the open and shut nature of Lily Chin's previous complaint, or the complaint that they're answering. Because if there truly was a ton of merit to this, they could have put somewhat more effort into the answer. Let's say that they don't have to. They're lawyers. They're good lawyers. They've got this firm in New York, in Times Square. No one's got an office in Times Square who isn't a surviving lawyer, let's say that, or seriously independently wealthy. So they've put forth this answer. Instead of what? What could they have done that they now can't do as much? They can't file a motion to dismiss. They didn't file a motion to dismiss for failure to state a claim. they more or less admit by filing an answer that they didn't have cause, they didn't reach the standard for a motion to dismiss. So to me, that actually says Lily Chin's case has a bit of merit, and that they're pushing forward into court for some other reason, whether just to delay for time so they can conduct a negotiation on a settlement now instead of having to worry about responding in court with the answer. They file a generic answer and then they conduct a settlement negotiation. That's actually a tactic I've used before. I have had defendants who have come to me too late in the 21-day response time, and I've said, well, we can file a motion for an extension of time, which will get you like 30 days, or we just file an answer, and that pretty much starts the case, but you can still settle your case while you're going along the way. So, that's a perfectly valid tactic to start negotiations by filing an answer. But I just wanted to point out to everyone, this is the most minimum, bare bones answer that still, I believe, survives as qualifying as an answer. And there's got to be something to that. There's got to be a reason for that. So can I make further conclusions for the attorneys that wrote this? No, I don't want to do that or even think about doing that. I think that would be unethical of me to speculate further. And Nico thinks that as well. Come here. Come on. We'll finish this up with a little bit of dog, lap dog here. They don't. It's not that they think they have a strong case or not. I personally, from the facts I've seen, don't think that Old Navy / Gap has a strong case against Lily Chin. That said, it's probably just a tactic at this point, and not an actual statement about the merits of the case. So I don't think anyone should be taking it as a look at Gap and Old Navy, what jerks they are because they responded with a generic answer. That's kind of normal. What's not normal is the copying that happened. Maybe it was just an oversight on someone's part or something. I have serious doubts that the CEO or leadership of Gap and Old Navy was like, just steal anybody's artwork and make pajamas out of it. We'll be fine. Or maybe there is a policy that they allow smaller artists' work to be used because what are they going to do about it? Who knows? We're going to find out. Or we're at least going to hear more about this case. Whether we find out that information or not, I can't guarantee, but this is a case, and so we're going to find out more about the case. I'm tracking it, I'm watching it, and I'll let you know when there are updates. So that is our show, everyone. Thank you very much to everyone for joining me. Thank you very much to the Patreon supporters that make this whole thing possible. We have Kareem Harper sponsoring at the $500 level in May. Thank you very much to Kareem. We are working hard on your story and we'll be in contact with you. Thank you also very much to my $50 plus supporters, DJ Gilcrease, John Steele, Gavin Barnard, Andy the Godslain, Kyle Mudrak, Eevi, Verement, Tayne, John H. Andersen, Sean McNamara, Michael Pearce, and William Gonzalez. Thank you very much for your support at the $50 plus level, and thank you very much to the $5 plus supporters scrolling on the LED panel behind me and on the screen on the video when we do the VODs. We had a very good week this week preparing the Jamie Walton interview and then shooting the Jamie Walton interview. Jamie Walton is the co-founder of the Wayne Foundation with Kevin Smith. Filmmaker Kevin Smith and Jamie Walton fight human trafficking together as the Wayne Foundation, and we are working on an edit to our 3.5-hour interview with her. I appreciate you all. I love you all. I am, of course, Leonard French, your favorite copyright attorney.
Thanks for joining us, everyone.